Scotland's legal system is unique, blending elements of civil and common law, and it's overseen by a network of courts responsible for administering justice. The highest court in Scotland is the Court of Session, which handles civil cases, and the High Court of Justiciary, which handles criminal cases. These courts are presided over by judges, known as the judiciary, who are responsible for issuing judgments, ensuring fair trials, and determining sentences. The Court of Session is the supreme civil court in Scotland, but appeals from its decisions can be made to the Supreme Court of the United Kingdom. The High Court of Justiciary is the supreme criminal court in Scotland, and its decisions are only subject to the Supreme Court of the United Kingdom on matters related to devolution and human rights compatibility. The judiciary in Scotland, with the exception of the Lord Lion King of Arms, is united under the leadership of the Lord President and Lord Justice General, who is the President of both the Court of Session and the High Court of Justiciary. Maitam. Majority of criminal and civil cases in Scotland are handled by the local sheriff courts, which are organised into 6 sheriffdoms led by a sheriff principal. These courts have exclusive jurisdiction over civil cases, with a monetary value up to $100,000, and can try criminal cases both summarily and with a jury. However, cases involving treason, murder, and rape are exclusively handled by the High Court of Justiciary. While the High Court and Sheriff Courts have concurrent jurisdiction over crimes like armed robbery, drug trafficking, and sexual offences involving children, most of these cases are heard by the High Court. The Scottish Courts and Tribunals Service, a non-ministerial department of the Scottish Government, provides administrative support for the courts. This service operates independently of the Scottish ministers and is governed by a corporate board chaired by the Lord President. The Scottish legal system recognises 4 sources of law: legislation, legal precedent, specific academic writings, and custom. Legislation affecting Scotland and Scots law is passed by the Scottish Parliament on all areas of devolved responsibility and by the United Kingdom Parliament on reserved matters. The Scottish criminal justice system has a tiered structure, with different courts handling cases of varying severity. The Justice of the Peace Courts are the lowest level, handling minor offences. Sheriff Courts handle more serious crimes that are not severe enough for the High Court. The High Court is the highest criminal court in Scotland, and it handles the most serious crimes, including treason, murder, and rape. Appeals against convictions can be made to the Court of Appeal, and the Court of Session is the highest court in Scotland, although appeals can be heard in the UK Supreme Court. In Scottish criminal trials, there are 2 types of proceedings: summary proceedings for less serious crimes and solemn proceedings for more serious crimes. The courts can deliver one of 3 possible verdicts: guilty, not proven, and not guilty. When someone is found guilty, sheriffs or judges have a range of punishment options available to them. Under Scots law, children under the age of 12 are not held criminally responsible for their actions, but they can be referred to Children's Hearings Scotland. Young people under the age of 16 are only tried in an adult court for the most serious crimes. This system differs from juvenile justice systems in other parts of the UK.